Speaker is Donna Lambert, and Donna Lambert has time seated by 6 individuals. That's Donna Lambert, seated time from William West, Mon Anna Dobbins, Andrew O'Donnell, Sophia Casio, Kimberly Cooper, and Sergio Sanchez.
Should I start? Good morning, council members.
Good morning.
Hi. My name is Donna Lambert. I would like to thank the San Diego City Council for taking medical marijuana seriously and putting in the effort to develop zoning regulations. However, I have a few concerns. This restrictive zoning and permitting process seems to be designed to limit the number of collectives and cooperatives. All zoning should be to further Prop 215 first, and secondly, SB 420, and not used to hinder or undermine the law. This restrictive zoning and permitting process is an elitist model that plays right into the hands of wealthy pot investors waiting to move in on San Diego with their exclusive license to sell and keeping prices high and continuing their pot monopolies. I am requesting that this City Council reject this restrictive permitting and instead accept the Medical Marijuana Task Force recommendations. In addition, there are 2 sections in the new municipal code that need to be changed to more accurately reflect the law. Section 42-1303 in the municipal code still places plant limits on plant numbers, and I'm asking for Section A through D to be stricken due to the ruling last year in People versus Kelly, which stated that plant limits were unconstitutional due to the fact legislation cannot override a voter initiative, and Prop 215 did not put plant limits or weights on patients. Therefore, that part of your municipal code is invalid and needs to be taken out. Secondly, the municipal code 42-1503 says all persons who collectively associate to cultivate marijuana must form a corporation. This puts an undue burden on small groups of patients that are actually following the literal reading of the law, which gives them the right under state law to collectively associate for the purposes of cultivation. I'm asking for Section 42.1503 changed to something reasonable, such as collective cultivation efforts involving 12 or more people or those who choose to use a storefront model for their collective or cooperative must organize as a corporation. 3 or 4 people cultivating together is well within SB 420. Patients have that right to get together and cultivate, and this municipal code here is implying that if 2 or 3 people are growing marijuana together, they have to have some sort of corporation. The City Council, having acknowledged that the activities described are legal under state law, should acknowledge that it is not a zoning certificate, which then makes the described activity criminal or not criminal. The city should not allow or fund raids, arrests, or criminal charges on these collectives which do not have zoning permits. SB 420 allows all patients who choose to collectively associate to be exempt from all criminal-related charges. We as a society need to move away from treating medical marijuana patients like criminals. The only real issue left that law enforcement should be concerned with is if the medical marijuana is diverted to an illegal market. It should be against city policy for undercover police officers to join collectives using legitimate medical marijuana cards and then arresting people for sales. In 1937, the Marijuana Tax Stamp Act was passed, and with this stamp, anyone who possessed the stamp could then grow cannabis. Prohibition was created by not issuing the stamp. The zoning amendments, the restrictive zoning amendments that are put forth here today are a result of a meeting this county had, and they produced a 300-page book called Don't Let Your Communities Go Up in Smoke. The whole book was about how to use zoning to undermine the law, and that is, I'm afraid, what is taking place today. So I asked you to reject that and go back and accept what the Medical Marijuana Task Force had recommended to you. Okay, thank you.
Thank you. The next speaker is Leo E. Lawrence. Leo E.